Hi. I guess good evening and greetings to everyone in Attorney De La Cruz's class. My name is Millicent Desiderio Dime, and I graduated from the Ateneo de Manila School of Law in 1996, where I had the honor to be classmates with your professor. We were both admitted to the bar in 1997, right after we graduated. And I have been a practicing lawyer since then. I'm also currently the legal director for Accenture in the Philippines, which, as you may or may not know, is an information technology business process outsourcing and consulting firm, which employs over 70,000 people in the Philippines. It's a multinational, and I'm very fortunate to lead a high-performing team of lawyers which provides support to Accenture in the Philippines. And well, before we start, thank you very much for inviting me. I hope that anything I say will not be used against me in a court of law, because all of this is based on personal experience, the things I've gone through in the past years, and I hope it can provide some words of guidance or inspiration, or even cautionary tale of what not to do. So, first of all, John Daly and Jappy sent me a list of questions, so I'll just go through them one by one, and forgive me if I ramble on. So first, I think John Daly wants to know who or what drew me to focus or specialize in commercial law as my practice. Actually, it was a very long journey. I never really thought of myself ending up in commercial law. Like many starry-eyed young lawyers, when I was in law school, I always dreamt to be a litigator. And that's what I did for the first probably 8 years of my practice. I worked for PECABAR under the late Senator Cayetano. Thereafter, I moved to Puno and Puno Law Office, where I stayed until I became a partner. And in all of the time I spent in the law firm, I was always a litigation lawyer. Of course, that involved commercial law practice as well, because like we used to joke around, the commercial law part of litigation is really brought about by the failure of the contracting parties to properly express their intent in contracts. And a lot of the time, we would be litigating on commercial matters which were brought about because of contracts that were improperly written or which failed to express the intent of the parties. So while I was a litigation lawyer at heart, I realized now that I was doing a lot of commercial law practice as well. I guess what made me shift from the purely litigation side of my practice to a more commercial approach was, well, I had milestones in my life. I got married, I became a mom. And the last case I litigated, and which really changed my mind, was this very high-profile kidnapping case of I don't know if you recall, because this was years ago, but the newscaster Ces Drilon was kidnapped in Mindanao. And it was a highly political case because the accused were, at the time, incumbent public officials in the area. So it was a dangerous assignment. And at the time, I had a 2-year-old daughter, and we were getting threatened, and it was just a very dangerous situation. And one day I thought to myself, I have to be responsible as a mother and as a wife. I have a family now. So maybe after I finish this case, it's time for me to move on and do something else. And fortunately for me, Banco de Oro at the time was looking for someone to lead their commercial law litigation team. So while I was still litigating, it shifted to a more focused type of litigation, was really shifted to a focus on large commercial transactions. I did not stay in BDO very long because later on I was asked to lead the legal to well actually to create a legal team for a multinational Australian company which had just set up headquarters in the Philippines called Macquarie. I successfully set up that legal team, but unfortunately, due to the European crisis at the time, the team was dissolved and I found myself at a loss. I didn't know what to do. And I'm not ashamed to say that at that point, I was actually considering finding a job as a call center agent, anything. So, in my desperation, I actually sent a mass text to everyone I knew saying, I'm looking for a job. I'm already a partner. I was a vice president, but at Banco de Oro, I had this high-paying job at Macquarie, but I really need a job, so I don't mind if I have to start over as an associate or start entry level. But fortunately for me, Accenture at the time was looking for someone to head their legal team. And out of the blue, I got a text message inviting me to apply for the position. It was very scary, and this is one thing I'll tell you. Don't let the fear of knowing that you don't know something stop you, because you can always learn. And that was my mindset at the time. I know nothing about the technology or BPO industry, but I have a capacity and a willingness and an eagerness to learn. So basically, I was very honest with my interviewers. I told them I had not worked for an outsourcing company, I had not worked for a technology company before. But to my mind, when you have the basic legal skills in hand, anything can be learned. And it's been a fantastic journey. I've been with Accenture for over 10 years now. In fact, I celebrated my 10th anniversary in the firm last January. And I look forward to the rest of my career in Accenture because it's been very rewarding. So I guess 2 points here is, one, don't be afraid to try something new. And don't let yourself be held back by your concept of what you should be. Because maybe what you're meant to be is something different from that. And in my case, I always wanted to be hotshot litigation lawyer. Corporate law to me was always mystical, boring, ethereal, not something I wanted to do. And yet, 10 years later, here I am. So, sorry for rambling on and on. Next question. What do you think are the key skills or qualities necessary to be successful in the practice of commercial law? I think the difference between being a litigation lawyer or a lawyer practicing in a law firm is your mindset. Because when you're being an associate or a partner in a law firm, your mind is always generally very adversarial. We hate to admit defeat. We hate to give concessions. And sometimes we get very fixated on the letter of the law. So we refuse to compromise. The biggest shift in my approach, and I think one of the most important qualities of a commercial lawyer, is to always think of yourself as supporting the business. Your job is to enable, not to become a roadblock. So when you become a commercial lawyer, your first impulse should never be litigation. In fact, in my career in Accenture, we have never had to go to litigation, into commercial litigation. Because I think litigation, everyone loses in the end. And, it's not just the expense and the time of going to a protracted court case. It's also the business relationships that may be ruined by a purely adversarial proceeding. So when you become a commercial, or if you want to become a commercial lawyer, what you have to think of yourself is, I am here to enable the business. How can I use my legal skills to find a way to achieve the goals of the business, but still remain ethical and compliant with the law? And most of the time, you will find that your opposing counsel or the counterpart in the other company would be thinking the same as well. Because your goal is not to win, really. Your goal is to find a middle ground that's acceptable to both parties, that would be mutually beneficial and profitable. So it's not really about proving who's right or wrong when there's a dispute, or even when negotiating a contract. It's really about finding a common, acceptable middle ground and being able to adjust and being able to find solutions to problems that you think are set in stone. For example, I see a lot of people arguing for weeks over clauses like venue and applicable law and force majeure. And yes, these are important, but if it becomes a point of deadlock, you have to sit down and think of it in a very pragmatic manner. What do I really get if I insist on this? What if the negotiations break down because I'm insisting on this point? Because I refuse to budge on the concept of venue. And at the end of the day, you'll realize, well, maybe I'm not being a good lawyer to my client if I'm so inflexible. So I think that's it, really. It's the mindset. Stop thinking of yourself already as an advocate, but think of yourself more as a bridge between your client and the other contracting party, and try to find a way to make the two meet in the middle in a way that's mutually beneficial. And lastly, leave a word of advice to encourage law students who may be interested in practicing or specializing in commercial law. I don't really consider myself as a highly successful person. I just know that I'm happy with what I'm doing, and anything I say from this point forward is purely based on my personal experience. But really, I think the advice I would give you is this. One, get a very thorough grounding in litigation. Get 1 or 2 years experience in general practice before you subspecialize into anything, not even just commercial law. Because I think the way that litigators approach issues is different from someone who has never done litigation. Because when you're in litigation, you pay attention to detail. You're able to anticipate what could go wrong. And if you've seen enough contracts being litigated, that stays with you. So when you become a commercial lawyer and you're drafting a contract, this will help you because then you'll remember, I litigated a contract before and this was the issue, and it stemmed from the bad wording of a particular clause. So you'll remember that and you'll think, how do I draft this contract so that I don't have that same problem? So I always, when I recruit for my team, and it's always commercial, it's a commercial law driven team, really, compliance and regulatory, that's our job. I always look for people who've had that background in litigation because I think that it's very important. The mindset and the approach adds value to you, and I think in the long run, that will give you an edge over someone who's done purely commercial practice in their life. Secondly, like I said, be brave. You have to let go of your preconceived notions and be willing to explore. Always have that willingness to learn. The law is evolving so quickly. Right now in my space, countries are looking at regulating artificial intelligence. They're looking at regulating the use of the cloud. There's so much in automation. There's so much on technology-based financing. A lot of these haven't made the law books because our lawmakers haven't contemplated that this would someday need to be things that have to be regulated, like fintech, for example. It's only now that we're catching up with regulations on fintech. So as lawyers, you have to be able to adapt quickly, and you can't just limit yourself to knowing about the law. If you choose a field, you have to know the business that you're supporting. So if you choose to work for a bank, you have to understand the trends of the banking industry as well, not just the banking laws. In my case, I work for a technology company. I can't help my clients if I don't understand the technology that they're producing. So I'm forced to learn about technology so I can be an effective lawyer. So ultimately, I think what you have to remember is if you have the courage to take on a challenge and the willingness to learn and the humility to accept that you don't know anything, then you're going to go very far. And I think that you're in good hands with your professor, Attorney De La Cruz, who's always been one of my idols. We've been good friends for so long. And I wish you all good luck. And maybe one day you'll come work for me. So have a good evening, everyone, and thank you again for inviting me. Bye.